Are you thinking about jumping into a real estate partnership or joint venture? Well, let me tell you something. One bad partner could cost you everything. I see it every day. Friends or family members go into business, but one of them ends up doing most of the work and the other doesn't hold up their end of the bargain. If you don't have a strong written agreement in place, you might have just given away a ton of equity or created a ton of unnecessary liability for yourself. It's a massive mistake that is so easy to avoid. In this video, I'm going to walk you through the top 10 key provisions that every real estate partnership agreement must include to protect you from a partner who doesn't deliver on their promises. After watching this, you'll know exactly how to protect yourself in your next real estate partnership. My name is Bishoy Hhabib, and I'm the realest real estate attorney you know. Over the past 12 years, I've closed over 1,000 transactions totaling $12 billion. And in my experience, the biggest disasters in partnerships happen when most people don't have a solid agreement in place to fall back on. That's why today I'm sharing the top 10 provisions every partnership agreement must have. Now, when I say partnership agreement, that could mean a joint venture, a partnership, or an LLC where all partners are members. For the sake of this video, these terms are interchangeable, and these provisions can be included in the governing documents, whether that's a JV agreement, a partnership agreement, or in the case of an LLC, an operating agreement. The first provision you should include is a right of first offer for new opportunities. You would never go into business with a partner who hid the best opportunities from the partnership and cherry-picked those for himself. That's why a right of first offer matters. To prevent this, your documents should include the following right of first offer language. Clearly define a new opportunity that must be presented to the partnership, including a property type, size, location, and investment parameters. Then you want to establish a formal process for presenting opportunities to partners, which includes required documents and analysis. Then you have to set a specific time frame for the partnership to evaluate and respond. So this might be 5 to 10 business days. And then what happens if the partnership declines? Can the partner pursue it independently? Under what conditions? And you got to specify if this obligation continues after the partnership ends or exits. So there might be like a 6 or 12 month period afterwards where they still have to bring, different opportunities to the partnerships. Now, you do want to include carve-outs for pre-existing relationships or property types outside the partnership's stated focus. So, for example, rather than a vague language like partners must present opportunities to the JV, you might want to use specific language like this. Any partner who becomes aware of a multifamily acquisition opportunity with 50 plus units within a 25-mile radius of the JV's existing properties must present such opportunity in writing to all partners within 3 business days. The partnership shall have 10 business days to express interest by simple majority vote. If declined or no response is received within the time frame, the presenting partner may pursue the opportunity independently without violating fiduciary duties, provided all pursuit costs are borne independently. It's also going to make a difference if you guys are going into business on a small project, or if this is like your partner and you guys are both full-time in it. Because if you're just doing, a little one-off project, you may not care that this person's doing other things, right? There's no exclusivity, so it doesn't matter to you. But if you guys are putting your blood, sweat, and tears into this big project or this big company you're building up, and your partner's doing similar deals on the side and you don't know about it, that could be an issue. So that's also a factor as well into whether you incorporate this or not. But this provision does prevent one partner from cherry picking the best deals for themselves while leaving the worst deals for the partnership. It also maintains trust while giving everyone clear guidelines about when opportunities must be shared and when they can be pursued independently. Now, number 2, roles and responsibilities. This is huge. In an ideal partnership, each party has different strengths and weaknesses, and therefore I excel at what my partner can't do and vice versa. So if you're each doing different things, then there's not much overlap, or at least there shouldn't be. But here's the thing. If these roles are not clearly defined in the operating agreement, you're asking for trouble. I've seen this happen time and time again. One partner doesn't pull their weight and the other partner is left picking up the slack. And this can lead to major tension. So what's the solution? Put it in writing and be as detailed as possible. I try to at least put bullet points inside the agreement of what each party is expected to do, and bonus points if you're able to list out objective metrics and KPIs. The reason for this is if they don't fulfill their obligations as you wrote them out in an operating agreement or partnership agreement that everyone signed, then you can tell that partner you're in default, and therefore I may have remedies, whether that's getting more profits, whether that's getting a salary, whatever it is. So here's an example. Party A is responsible for managing the property. This is way too broad. Try this. Party A shall be responsible for property management, which specifically includes collecting rent from all tenants by the 5th of the month, responding to tenants' maintenance requests within 24 hours, coordinating repairs with approved vendors, with authority to approve expenses up to $1,500 without partner B's consent, conducting quarterly property inspections with written reports, maintaining a 95% or higher occupancy rate, keeping vacancy periods to less than 30 days, providing monthly financial reports by the 10th of the month, managing tenant relations, including lease renewals, rent increases, and conflict resolution, overseeing property marketing when vacancies occur, and so on and so forth. Big difference, right? Now you can actually hold your partner accountable. You also want to make sure that if they don't fulfill responsibilities, there are consequences. Maybe, like I said before, their ownership percentage is diluted, maybe you get a preferred return or a salary, etc. Laying this out prevents you from having to go through a formal legal proceeding to get what's equitable and gives your document some bite. This ensures that everyone does their part to move the business forward. And I'll note this is usually a pretty easy conversation on the front end because you've presumably discussed this in some capacity with your partner. You're gonna do this, I'm gonna do this, etc. But if you don't do this up front and you don't put it in writing up front, people get amnesia. So failing to do this, it can lead to some awkward conversations on the back end. Point is, do it early on, get it in writing, it's a lot easier. Number 3, decision making. Who makes the calls in the partnership? Who decides how the money is spent, or who hires the employers or contractors? It's crucial to know where the power lies. Your operating agreement should establish clear decision-making hierarchy with specific dollar thresholds and approval requirements. Consider implementing a tiered approach. Day-to-day operational decisions can be made by party A, and then you might define what an operational decision is. Major decisions exceeding $100,000, refinancing, or selling the property require unanimous consent. Establish a dispute resolution protocol if partners reach a deadlock in decisions. This structured approach keeps everyone on the same page, creates accountability, and significantly reduces the potential disagreements or unilateral actions that could damage a venture. If you have just 2 partners, you should probably come up with some sort of a way to break that gridlock if it's a one-on-one, right? So how is that tiebreaker gonna happen? Number 4, profits and losses allocation. It may sound simple, but it can get complicated, right? So let's say one partner is working 20 hours a week on the project, the other's only working 5. If you've agreed on a 50-50 split of profits, that may not be fair to the partner doing more of the work. So your agreement should allow for a flexible distribution of profits and losses that reflects the actual contributions of each partner, both cash contributions and sweat equity. Maybe the one putting in more work gets a bigger chunk of the profits. Or if one partner is more concerned with the tax benefits and doesn't need the income from the partnership yet, you could allocate more of the losses to them. But just remember, everything you do here has to make economic sense and pass the IRS's sniff test. If you have questions on taxes, definitely reach out to a tax professional. Number 5 is a right of first refusal, and I'm dealing with this now, it's very important. So a right of first refusal, or a ROFR, gives you the right to buy your partner's membership units or shares before they go and sell them to a random person. It's important because nobody wants to be in business with a partner they didn't choose. A ROFR gives the current partners an opportunity to keep new partners out by giving them first dibs on any shares that become available to purchase. But you want to make sure you have good ROFR language in there. So for example, any legitimate third-party offer to purchase an interest should be first offered to existing partners. Establish a clear notification process requiring written notice of the third-party offer with all material terms disclosed. You have to specify timeframes for existing partners to exercise their ROFR. 30 days might be typical. And if more than one partner is interested, they can all purchase the shares pro rata with their existing interests. So if you have 3 partners and they own 1/3 each and one of the partners wants to sell, the 2 partners that are wanting to stay in the business probably have the right to purchase it 50-50. That's pretty fair. You also want to lay out the payment terms and closing timelines for the ROFR. So for example, a lot of times what you see is if someone exercises that right, they may have the ability to pay that off over 12 months with an interest rate included. And it's all set out in there, so there's no negotiating after the fact. If the ROFR is not exercised within the time frame, then the selling party can proceed with a third-party sale. And number 6 is buyout terms. So what happens when one partner wants out? Well, that's where buyout terms come into play. Maybe one partner gets an offer they can't refuse, or they just decide the partnership isn't working for them anymore. The agreement should clearly outline how and when a partner can exit and what their buyout will look like. It's not just about the numbers. Sometimes you have to plan for a penalty if someone leaves too early. So if a partner wants to exit in the first few years, you might set a rule where they only get 75% of their capital back. That's fair to everyone involved. Additionally, you might want to include tag-along and drag-along rights. Tag-along rights allow smaller partners to participate or tag along in any sale initiated by a majority shareholder on the same terms and conditions. And drag-along rights require smaller partners to sell their share if majority shareholders decide to sell their company. In other words, they get dragged along, ensuring that the small guys can't stop a sale that the big guys want or that makes sense for the general partnership. Number 7, dispute resolution. And this is a huge one, especially when there's only 2 partners and no tiebreaker, like I was just saying. If you and your partner hit a rough patch, how are you going to solve it? This is where having a clear process in place saves you time, money, and a whole lot of stress. You can require mediation, for example, so there's a disagreement, you don't jump straight into a lawsuit. You can resolve things calmly and efficiently, keeping the business intact. Oftentimes, I ask my clients if there's a neutral and disinterested third party they both respect, such as a mentor or a mutual friend in the industry, and list out that person as a tiebreaker. Predetermining this individual mitigates everyone's risk and uncertainty. Finally, if you do have to litigate, make sure you have language that allows the winning party to recover legal costs, because believe it or not, that is not automatically included if you win. Number 8, non-compete and confidentiality. This is a big one. A properly structured non-compete and confidentiality provision protects the business you've both poured your blood, sweat, and tears into, and should include these key elements. Number 1, clearly define confidential information. So proprietary methods, financial data, investor lists, vendor relationships, property acquisition strategies, general contractors, tenant information, and business opportunities presented to the partnership. Number 2, specific geographical restrictions. You can't just have it all over the country. It has to be limited to a reasonable radius. So it could be 5 miles to 25 miles from the existing properties or your offices or target acquisition areas. You also have to define a time. It can't be perpetual. So typically you would say 1 or 2 years post exit. Otherwise it may not be enforceable. You also want to detail what's prohibited, right? So for example, directly competing in the same asset class or using the same investment strategy, soliciting existing investors, right? Existing partners, existing vendors, pursuing opportunities that were first presented to the JV, snaking your deal, using proprietary underwriting models or business systems. You definitely want to include carve-outs for pre-existing relationships and businesses that the partners brought into the partnership, right? So if I'm going into business with you and I already had this pre-existing relationship with these people, or I'm already doing, this type of investing and we go into business, I wouldn't want to be precluded from doing that if we weren't in business anymore, because I was already doing that. You didn't help me do that. And so it's only fair that you let that partner go back and do what they were doing. So that's what I mean when I say a carve-out. You also could include a liquidated damages clause specifying financial penalties for violations of this. And then you want acknowledgement that injunctive relief is an appropriate remedy for breaches. And when I say injunctive relief, what that means, you'll hear this a lot in real estate, is you can get a court to stop that person from continuing. That's usually a temporary relief that's granted, that can be granted much quicker than a lawsuit will be resolved. So the way it would work is, this partner is soliciting my clients. Well, I could sue them and they could fight back, and that could take 2 or 3 years. In the meantime, I can go to a court and say, court, look, they signed this agreement saying they wouldn't solicit my clients. You need to issue an injunction or injunctive relief, which stops that party from continuing in this, at least temporarily, right? A temporary injunctive relief, sometimes we call it, to say, okay, you have to pause, let's figure out what's going on here. And that makes the parties come negotiate in good faith. Now, the enforceability of non-compete varies by state, so tailor those provisions to conform to local state laws. My theory and my idea is put it in there. It's better to have it in writing than not, and then you could always scale it back if you have to. Remember, the goal is not to prevent your partners from making a living. It's not to be petty. It's not to spite them. The goal is to protect the legitimate business interest of the partnership and ensure that the shared knowledge and resources aren't weaponized against the partnership after someone exits. And that's how the courts view it, by the way. If the courts view it as punitive, if the courts view it as you're just trying to get back at someone or you're trying to prevent them from making a living, it will not be enforced. That's how the courts look at it. If you're protecting a legitimate business interest, the courts are much more likely to approve, thumbs up, give it the okay. A well-crafted provision offers protection while remaining reasonable enough to hold up in court. Number 9, default remedies. What happens if the partner doesn't meet their obligations? What if they fail to contribute capital or don't pull their weight? Your operating agreement should specify what happens in these defaults, because if it doesn't, then what? Okay, you're in default. What do we do? Am I going to sue you? Because there's no clear remedy in there. So now we could have a whole battle over what happens because you're in default. So a default remedy section should clearly define both what constitutes a default and the specific consequences that follow. So define specific default triggers: missed capital calls, failure to perform duties for 30 consecutive days, a breach of fiduciary duties, or a criminal conviction. Then you want to implement a formal notice procedure. For example, written notice of a default with a specific cure period between 10 to 30 days, depending on what it is and how hard it is to cure. Then you want to establish graduated consequences based on severity and frequency. So a first default might be, and I'm just making this up, a reduction of profit distributions by 25% until remedy. Then a failure to cure, maybe you convert ownership interest to non-voting status. And then repeat defaults, maybe it's a forced buyout at 70 or 80% of market value or book value, whichever is lower. You also want to include cross-default provisions where a breach in one area constitutes a breach in all areas. You also want to specify whether the non-defaulting party has the right of first refusal to purchase the defaulting party's interest, and detail how ongoing project responsibilities will be reassigned during default periods. Another thing that I see is two parties. If you did what I said earlier, you listed out the rights and responsibilities, and one party's not pulling their weight. Maybe you have some sort of a preferred return or a salary going to the partner who's doing extra work. That's how I structure them, because you want to make sure that the person who's doing more is compensated. You also want to make sure your remedies are commercially reasonable, or they may not be enforceable. To the point that I just made a minute ago, courts want to see that these are reasonable things. You can't be punitive when dealing with your business. It can't look like you're trying to hurt the other person. It can only look like you're trying to protect yourself and your business. That's okay. So you want to create meaningful incentives for all partners to fulfill their obligations. And if you have these provisions clearly outlined from the beginning, it sets the proper expectation and provides a clear roadmap for handling difficult situations. And finally, number 10, ownership and capital contributions. So what do I mean when I say that? Well, when you're putting together your JV or your partnership, you need to clearly define how much money each partner is contributing and what they'll get in return. It sounds simple, right? But here's where things go wrong. So let's say you both agree to contribute 50-50, but halfway through the project, you need another $60,000 to finish the project. What happens when partner A has no money left to contribute? Should partner A's ownership be diluted? Can partner B bring in a third party? If partner B covers the full amount, how are we going to compensate him or her for that additional risk? That's why your operating agreement should clearly define what happens in this situation. If one partner contributes more capital, their ownership stake should adjust accordingly, or it should be construed as a loan at an interest rate agreed by the parties, and typically it's a higher interest rate to accommodate that party. No one likes feeling like they've been taken advantage of, especially when there's more money on the line. So there you have it. 10 key provisions you absolutely should include in your partnership agreements, operating agreements, joint venture agreements, whatever the structure you have. It doesn't really change all these terms. These are fundamental, especially in real estate. Remember, trust is great, but a solid legal structure is what truly protects you from disaster. Don't learn the hard way like so many others have. If you found this video helpful and want more information on protecting yourself in your next real estate deal, click the link below to schedule a free strategy session with me. Let's make sure your JV is set up for success so you can focus on what really matters, growing your business. Thanks for watching, and I'll see you in the next video.